Good morning, everyone. I'm glad to be with you this morning for this Tuesday webinar. But to be honest, I must thank my virtual assistant. Today, he woke me up. He offered me a quick view of my day. He helped me to avoid traffic jams. And he reminded me that this webinar was about to start 5 minutes ago. A few years ago, this story would have come out of a science fiction novel. Today, artificial intelligence, or AI, is in our daily life. My name is Claire Duranton. I work here at the EUIPO, and I will moderate this webinar for you today. I'm neither a software engineer nor a geek, but like you, I feel concerned by AI, by artificial intelligence. I'm also curious and a little bit anxious. Like you, I have questions about AI, about the protection of AI products, their ownership, and much more. Please step in, ask your questions during this live session at any moment through the chat. Even if 1 hour is not enough, I hope this webinar, organized in collaboration with the Center for International Intellectual Property Studies, will answer some of them. It's our pleasure today to welcome our special guest. He's worked several years for the European Patent Office, dealing with inventions in the AI field, from image analysis to pattern recognition to machine learning. He recently joined the CEIPI as professor and researcher on these issues. Please, Jean-Marc Deltourne, the floor is yours.
Many thanks, Claire, for the kind introduction. I hope the sound is okay. You let me know otherwise, okay?
It's okay.
Very happy and excited to be here at the EUIPO webinar series today and to talk about a very broad subject. So I'll try to be concise, but I'll see what I can do. We'll cover many topics related to the intersection of AI and IP, intellectual property, not just patent, not just copyright, but the whole gamut of IP rights. It's a broad subject. Hope there would be interested questions coming up at the end, and that's part of the idea also to generate some kind of discussion with the larger community. So the topic is quite broad indeed, and I'll give you I'll start with a sort of a conclusion, go-to sort of a take-home message, if you will. First, that artificial intelligence is about technology, for sure. So we'll talk about neural networks in the coming slides, but it's also about a broader concept, a notion of automation, the delegation to machines, particular kind of machines, algorithms, of properties usually associated with cognitive properties usually associated with human beings. That's one thing. So it's a broad concept, automating society. And it touches many, many broader aspects broader than AI, broader than IP, sorry. And the second aspect is that humans are not out of the loop. Actually, we'll see today that they're very much present in the architecture of artificial intelligence, and it matters a lot for IP. So one other thing that matters a lot for intellectual property and for legal matters in general is the matter of definition. So what is artificial intelligence? It's a very difficult concept to define. It's a very large and broad notion, elusive by all means. It's a moving target because technology evolves all the time. So it's not a bad idea to come back to the roots, to the definition by John McCarthy in 1955, who actually coined the term at a conference in Dartmouth, and specifying basically that machines behaving in ways that would be called intelligence, if a human were so behaving, would basically encapsulate the idea of artificial intelligence. It's a very behaviorist definition that reminds us a bit of the notion of the imitation game by Turing, where we test whether a machine is deemed intelligent just by interrogating it. If it would pass for a human being, then we would call it intelligent. So that's really rooted in that notion. And in practice, it covers a collection of theories, techniques and applications that simulate human behavior. That's one aspect reminiscent of that behaviorist definition, which means perception, for example. Vision is one thing, hearing is another one. Making decision, deciding to swerve left or right if you're in an automated vehicle. And I grade out that notion of understanding because I think it's a bit more complicated and we're not actually there yet. We'll see that we're still in a very narrow path of narrow AI. So imitation and simulation is one thing, but there's sometimes also cases where AI extends human attributes, goes beyond the capabilities of human beings. In some sense, we call them super intelligent properties, where they work better, faster, for example, than human beings. That's one possibility. And AI is already there, as Claire mentioned. It woke her up this morning. Those bots are pretty much present everywhere on our computers, on our telephones, on our desks. And it's part actually of a broader, larger scope of societal transformations that started maybe around the 18th century with a series of industrial revolutions. And AI today is participating in that transformation of society by incorporating new attributes of machines that can decide or help humans decide independently from direct control. So that's part of that fourth industrial revolution. And beyond this notion of disruptive properties of AI, it also becomes a sort of a commodity. AI today is something that we would call a general purpose technology. It means that AI can be applied to pretty much all the fields. All the fields in society are being touched by AI, transformed sometimes radically. From images, where medical analysis and scene understanding are actually a very important field of application of AI. Speech, as Claire mentioned this morning, where you can interact with a bot, and that's part also of their natural language processing, the NLP application of AI today. Control, I mentioned vehicles. That's also a very fashionable topic where AI is being applied, but more generally in robotics. In financial industries, for credit allocation, for stock prediction, for insurance claims evaluation, and as we'll see today again, something related to a slightly different angle of AI, not just decision making, not just making prediction, but producing new artifacts, generating designs, objects in biomedical application, many new drugs, for example, new vaccines, but also new pieces of art, new works of art, music, and graphics.
Jean-Marc, if I may, where is it used most commonly now? In which field? Most used?
It's actually quite hard to say. I would say that image, it changes. It's a moving target, as I said before. And actually, with new transformation, algorithmic progress, we see it apply in different fields. One of the first where we saw massive benefits was actually image processing. This one, the one I'm showing before. Then speech became very important. And today, I would say that natural language processing is the field where we see the biggest transformations, sort of the more disruption. But in that example, that's a good one because it's just a few years old, actually 4 years old now. And it was an important case where for the first time, I would say, AI application, algorithmic application, machine learning application were working better than the best specialists in the world here at detecting or classifying lesions of the skin. So it poses actually important deontological questions there, because would you trust a machine that works statistically better than any human, any clinician in the world, but can't really explain the decision, or a human being? So you see, it's actually that part of that broad discussion we need to have about AI, but that's part of the big disruptions we're seeing today. Another one is a scene understanding and planning for cars, where just by looking at the scene at the bottom of the screen, you see a sort of a panorama that would be perceived by the Waymo vehicle, as Waymo is a branch of Google. And the scene is analyzed automatically on board by the system that can automatically identify the subset, the part in an image. It's actually by no means an easy feat. Actually, it's actually quite amazing capability of those systems to be able to get a sense of what is in front of this camera, make sense of those images. Very complex and very, very important. And we see, of course, we're using it all the time, not all the time, but often. Translation is one field and related to natural language processing, but also translated not one just from one language to the other, but also from images to text. And for helping maybe disabled people, for example, you point the camera at a scene and the telephone or the platform tells you what is there in front of you. So you can see many rich applications. In art, we've seen in the press Edmond de Bellamy, a portrait generated by a particular neural network called generative adversarial network, sorry. or the next Rembrandt, where AI was used in conjunction with human beings. Also, humans are very much present in these processes. There's no automation, no pure automation at all, but they participate in the creative pipeline. And we're seeing this in the arts in general, in music as well, with Daddy Scar, Benoît Carré, and François Pachet used neural networks and other tools to produce a piece of music inspired by the Beatles, so learning from music, from existing music. And Tyrone Southern also created a record, but there's many examples there. So it's actually important. We see it in fashion as well, where you can produce and recommend fashion trends, maybe generate new trends also using AI, and generating molecules for vaccines, for drugs in general. So that's also, you see the gamut of applications of AI is quite wide. And that translates immediately in massive investments from big companies. I mentioned Google, you could talk about others, Microsoft, Facebook, Baidu, etc. Alibaba, active participants in that landscape, but also startups. And just showing you that example because it points to the fact that in the last roughly 10 years, 10 to 12 years, that period of time where AI became so popular, we saw investments in startup multiplied by a factor of 20 or about 20 now. Massive implications it did for society. So why now? I mean, and why is that transformation? How can we explain that? Well, we've seen actually a paradigm shift. That's quite important to go back just to the technique, just for a moment. No mathematics, very simple explanation, but to give you a hint of what it is that we talk about when we talk about AI and the importance of that dimension for IP protection later on. So what happened actually is before the mid 2010s and at the current times, from the mid 70s to the late 90s, people rely on a different kind of AI, more symbolic AI, where rules were extracted by interrogating human beings and they were elicited and put together by systems in a set of if, then, else statements. And that worked well, actually. It was actually something that was effective for some applications where we could do so, where we could find those rules, where human beings were aware of the rules and could list them. Of course, it was limited to a certain number of a level of complexity, tens or hundreds of parameters at most, and also only to the case where indeed human beings are aware of those rules. I mean, if I were to ask you what are the rules for walking or for understanding a scene in front of you, like the one we saw before, it would be very hard indeed, probably impossible. So people decided to investigate different means and went to a different trajectory based on statistical learning. And in that case, the rules are not exactly elicited directly by human beings, but I learned from data. So we collect data, we analyze the data, we find correlation and patterns in those data. And from these correlations, some rules, we call them a model, an inference models, are derived. And the rules are just the equivalent of the inference model is equivalent to the rules I mentioned before, but now we can we can play with not just hundreds of parameters, but maybe billions of parameters, hundreds of billions of parameters. So you see the level of complexity and the nature of the problems that can be tackled with that particular framework can be very, very different from the one that could be approached before. And it means also that human beings are somewhere in the pipeline, but not exactly at the same place. They're not exactly the one stating the rules. Maybe there would be the chef d'orchestre, there would be the one guiding the whole pipeline, but not exactly the one defining the rules per se. So what are those models? Well, essentially they act like a filter. It's actually very simple in principle. The model, the inference model, the rule learned from data are really working like a filter between sensor data observations coming from a microphone, from image, from a vehicle, for example, if you're looking at actuators and sensors in the car, from text, and I try to make predictions. Prediction could be a category, yes, no, a value, for example, a probability, a prediction, will it snow or rain tonight? Also, as I said before, the generation of a new object, a new molecule, a new trend in fashion, or a new object, a new piece of art, for example. So behind this model, we see that there are large choices of options. I'm just giving you a couple here to give you a sense of that variety, but there are actually many, many more. I'll give you another slide. We see that there are there are a cornucopia of options there. So a filter, a machine learning model could be in that case a decision tree, and it's a popular model in certain instances where we need to understand, for example, the decision process. And it works by decomposing progressively in a hierarchical fashion the input data in simpler and simpler rules until the point where we can decide whether, for example, it's a square or a triangle and make the correct prediction based on this sort of sequential decomposition. It's an important model in situations, as I said before, where you need understanding. For example, in medical application, for deontological reasons, the clinician need to be able to give a sense of the reasons behind the decision. And in a particular case, it could be legally important to know how the system came with a prediction. So in that case, that's a good model. But that's not actually the one we're using most today. For many reasons, I'll touch upon the reason in a second. We're using a different kind of model called a neural network. You all probably have heard about neural networks today. Just a very, very quick prediction without much math for sure. I'm not going to go into mathematics here, but giving you a sense of what it is and how it works at a broad but actually a reasonable level. Here again, we go from data to prediction. The intermediate step is a neural network. It's not a decision tree anymore. And it works by getting inspiration from biology. Very early on, people realized that if they were to mimic the properties of human beings, well, why not look at what makes us think, what makes us intelligent? And by looking at very specific units, the one simpler unit in the brain is the neuron, we could maybe try to approximate those neurons, make something that looks like them, like a model, and try and make it work, to make predictions. So people have tried that in the 50s. Rosenblatt in mid-50s, for example, came up with a perceptron model, very, very simple model that makes something like an average. So we could actually do it by hand. All those calculations are very, very simple. There's no high mathematics there. And so each neuron is a very simple approximation from a biological neuron. And that works by making a weighted average of its input and thresholding that average. So something very, very simple. But it's important to realize that basically there's just parameters associated with these neurons. And the whole system is a collection of parameters. The neural network is organized in units. Those units are the neurons that are put in layers, interconnected by sort of wires, if you will. And to each of those wires and to each of the neurons are associated parameters. So what does it mean to learn in that context? Well, learning is a bit like a game. We're going to start in the context of supervised learning with images and labels. So we've taken the time to collect images, faces here, it's before the machine. So we do that by hand. We know that there is a face here. And we're going to try and teach the machine to detect the face, to recognize if there is a face or not in that particular picture. So to do that, we're going to try and compare a prediction by the machine to the known label, right? And at the beginning, the machine starting a bit randomly, makes it wrong prediction often. And the idea is to try and each time the machine makes a wrong prediction, which is the case here, we're going to try and correct the values of all those parameters that I mentioned before. So we do that many, many, many times because we're using computers. We can do it very fast. And by repeating that process many times, we can lower progressively the level of errors and eventually obtain a classifier, a model that is satisfying and that we can deploy in the field. All that is machine learning. All that is just, I would say, AI. So AI is just a game of optimization, finding the right parameters. And for that, to solve that problem, people, very smart people, of course, have found recipes. It looks like a craft sometimes, more than engineering, more than hard sciences, to find ways basically to guide the machine towards the right solution in a very efficient way. So once you've done that, you can deploy the model in the field. You can deploy it on your smartphone, for example. That's one way to make it work. And different, I'm just giving you acronyms. I'm not going to give you the name of those, just to show you there is also a variety of options in terms of neural network architecture, just not just one. Actually, a new type of neural network, there's a choice to be made here, depending on the category of objects, images, audio, or text, and applications, if you want to do image recognition, speech recognition, or translation. So all those things give you a sense of what it is. And once you've learned that model, you can deploy it and it sort of hopefully work. Just to mention here, you've seen me talking about AI and machine learning. I'm just giving you a sense of what we can and cannot do. At the moment, artificial intelligence is very, very narrow. It means that we specialize our model to something very specific. You see the choices before. I'm going back to the slide before. Here, it's a different category of model that works with text than one that will work with images, for example. Okay, sometimes you can blend and be creative with the models, but in principle, you focus on specific applications. And that's a definition of artificial narrow intelligence. That's where we are, that's where we stand, that's where we talk about. There's no Terminator, no machines that can take over the world. It's not artificial general intelligence. That is science fiction, the way Claire was mentioning before. That's actually, maybe in the future, maybe not. Nobody knows. Nobody has any clue about the moment where maybe artificial general intelligence may happen. In fact, we're very satisfied and actually impressive enough what artificial narrow intelligence can do. And I'm just highlighting that with a cross just to make it really clear and giving you a quote from Professor Andrew Ng from Stanford. He's also chief AI engineer at Baidu. But he stated that essentially the same thing today. AI is far from being magical or even strong AI, which is equivalent to the general AI I was mentioning before. Instead, what we have today is a weak or narrow AI. That's where we are. Weak AI is focused on the narrow task, one narrow task, and can only be used in a limited context. A problem, an AI that you've trained or made to work at a chess problem cannot be used for translation, or you cannot put the same model in a car. So you see, we specialize things. We divide and conquer, basically, by approaching a very, very narrow topic and trying to make it work very well. And we do.
Jean-Marc, sorry, may I interrupt? I have a question. First question that is about data protection, actually, talking about narrow AI. Do you think AI may pose a threat to data protection, something a bit wider than what we were discussing, or the opposite? Could data protection laws be a threat of AI development?
Well, it's a very broad question. It doesn't have to do much with narrowness of the AI as such. AI, of course, is connected to data, and data protection is a very important issue, in particular in Europe, where we have a framework to protect personal data. We'll see in a moment. Maybe I'll come back, if you will,
sure.
If I may, to that question in a second when I talk about the model and trade secrets. I'll keep that in mind and answer the question. I won't forget. But I just wanted also to mention the challenge of defining AI. I think it's an important one for lawyers, for practitioners in the field of IP, because we also brush quite quickly sometimes that issue of definition. And it's an important one. Why? Because AI actually is not one thing, it's many things. It's an evolving and rich landscape that covers symbolic AI, the one I mentioned before, the expert system that were used in the 80s, for example, but also very different kind of processes like genetic algorithms, something inspired from Darwinian selection, and machine learning, the way I presented it before, with neural networks or decision trees. And you see there's plenty, again, of choices to be made here. So human beings are selecting the right tool for the right trade. Today, neural networks are something like a Swiss knife, but it's still a tool. Okay, and you pick it for the right reasons, you knowing of the limitation also of that particular tool. So the definition is important, and the challenging of protecting AI moving towards IP now is also a difficult one. Why? Because AI is not a singular moment, a singular action. It's actually a distributed process, starting from data, and we talk again about the personal data and the protection of data in a second, where we need to collect, to pre-process. There's a lot of work. Labeling, I mentioned that before, with a supervised learning, where we need to put a label on each images to train the machine. That's work. That's human being working at that. The learning process as such involves many, many choices, action, decision by human beings, from coding, software, and libraries, defining the architectures and the algorithm at work in the statistical learning process, but also finding the parameters. We call them the hyper parameters, the one that tune the system. All that is very crafty, very engineering related, but hard work. The model produced by that system also requires work, validation to make sure it really works. It's not just fantasy, updating it when it's necessary, being able to use that model to transfer from one field to another. We can, for example, train a model to translate from English to French, and then modify that model to translate from French to Spanish. That's a possibility. And then working on access, interactivity, interfaces, for example, using application programming interfaces. And then there's the whole application stage. You see, all those things require investment, require thinking, and could be the locus also of an intellectual property right. AI is a multifaceted entity indeed. We can see AI as a technology, but we can see AI also as a set of possible, expression, a code, a training process, a network architecture, training data, an inference model, as I introduced before, application, or even hardware. All these things could be facets of AI. And again, it points to the difficulty of having a sort of a monolithic vision of IP protection for AI. In fact, we may need to look at all of those facets individually. And that's what I'm going to try and do today in the following slides. Looking again at all the IP rights that could be involved, copyright, patents, sui generis rights on database, because we're talking about data, trade secrets, very important too, contracts. I'm not going to talk about contracts, design, and trademarks today because it's actually a bit less relevant to the protection of AI and its products, but they're part of the game as well. Let's start with copyright, for example. Was there a question? Sorry,
yes, sorry, Jean-Marc. There's a question a bit broader. What expectations businesses should have if they're starting to implement the AI, and where should they start? So you had the model just one slide before with the IP protections.
Right. I don't know if you're on this one or
this one,
I don't know
yeah.
which one.
Next one.
I think, and that's going to be maybe just for me to give you a hint of the conclusion as well. What matters for companies is to identify the value and the risks.
Mm-hmm.
And value may be distributed as well as risk. So it's very important to avoid focusing too much on one aspect of AI, but try and have an integrative view of AI, put it in context. When risks are involved, for example, in relation to data, so I'll try to squeeze in my answer now, we need to be very much aware of the flow of data in that pipeline. That's also very, very important for companies just to avoid making big mistakes. The sanctions with the GDPR are very stern and high, so we need to be careful. And data, because they're permeating the process of machine learning, machines learn from data, and sometimes personal data and even sensitive data when we talk about medical applications, for example. That's something very, very important. So risk mitigation, creative process, human beings, who are the human beings that are creating that value? And I'll try to give you sort of maybe some clues on how to proceed about that particular question.
Thank you.
So going to copyright, computer programs, of course, are protected by copyright, and it's indeed a very fast-moving field. Looking at GitHub, it's a platform where people can put their software and share them. We see that the AI activity is dominating the field with respect to other software, at least in terms of gradient. It's moving very fast. It's increasing at a fast pace. So indeed, many people are working on producing those codes and they want to protect them. So to protect them, we have a directive in Europe that tells us that particularly the protection applies to the expression of a computer program. But ideas, principles that underlie any element of a computer program, for example, interfaces, are not protected by copyright in this directive. So that's an important concept, because what matters what it tells us is that indeed what is protected is this, the particular expression, the wording of the concept, the way it's being put on paper, or on the screen of a computer, on the memory of a computer, or the object code, the code translated to a set of zeros and ones that the machine can understand. That is the locus of the protection of copyright. What is not protected by copyright is the algorithm, the idea behind. And oftentimes, it is really where it matters. And the code matters. You want to protect a particular expression, that's fine. Copyright is an effective tool for that particular means and that particular objective. But if you're interested in the idea behind the concept, the algorithm, then copyright is not actually the right tool. We'll have to look elsewhere. Trade secrets could be an idea there. What is a secret? Well, we have again a directive in Europe, a recent one, that harmonized the treatment of trade secrets in Europe and gives us a definition of a secret. There is a definition. We have an intuition, of course, but there's a legal definition of a trade secret. And it has to be an information. It has to be kept secret. If not, tautologically, I would say it's not a secret anymore. It has to have commercial value due to the secrecy. And we have to keep measures, either legal or technical, to keep it secret. So looking at AI, many aspects of AI, that multifaceted object could be actually, could fall under that definition. The training data could be kept secret, it has value, we saw that before. Neural network architecture, the topology could also be kept secret and probably requires investment, so it has value for many reasons. The machine learning process, and also the output of the training process, the model. So it seems okay. In fact, looking at that, you can say trade secrets are a good option, but trade secrets don't protect against reverse engineering unless contractually agreed. But in practice, reverse engineering is a lawful way to acquire and to investigate the way the object works. And to try to reverse engineer is part of the possibility that anybody can try to make it to replicate that object if it's signed a contract against that possibility. Can we do that with AI? Well, actually, until recently, we weren't sure, but we saw that works are appearing that hint at that very possibility. We can reverse engineering the black box neural networks, even the large one, and as pointed out by this team here a few years back, 2 or 3 years ago, internal information about the model, the architecture, the procedure, which means the machine learning procedure, the training process, but also the training data can be reverse engineered. So it's important in connection to the Claire's question before, because here again, you see that the data may not be strictly protected. Even if you keep them secret from the onset, from the beginning, maybe they can diffuse through that object, the model that is being deployed in the field later on. If you're not careful, it's not always the case, but if you're not careful, it's a risk. So you have to be aware of that as well and try to take action against that if that matters. So attributes of the neural networks can be exposed in that way. And in fact, trade secrets may not be an obvious solution to protect your AI model or your machine learning process or your corpus of data. Again, in some cases, yes, but at least you have to ask yourself that question. The sui generis right on database is another option. Why? Because we talk about data, and sui generis database rights basically protect the investment in relation to obtaining, verifying, or presenting data. So if you collect many data, if you work by knocking at a door or putting a label on an image, all those things, the aspect not putting a label on an image actually, but collecting the images, for example, that example, the training example I was giving before, all these things require investment in time, in money. And for this reason, the sui generis right can be invoked to protect the access to the data and prevent people from extracting substantial amount of data from the database. That's a right, that's a protection, all right? But again, there's always a but. The European Court of Justice told us that there were limits, in a sense, to this protection. And in fact, what is not protected is the creation of data. So the collection of data is okay, but the creation of data is excluded from the protection. It's very important in many fields of AI, where indeed we participate in creating information, in creating data, not just collecting it. For example, the labeling action of assigning a value, connecting a label to an image, for example, is an action of creation. It wasn't there before. You as a human being invested time, but it's an act of creation. there's a field in medical application, very important one, where there's a scarcity of data. There's not enough data for the lesion example I showed before. Maybe you'd like to have a large amount of data, and actually you need a large amount of data to train those deep learning systems that we are using today, the deep, large neural networks with billions of parameters. Because there are many parameters, you need a lot of data. But when data is scarce, maybe you need to augment the data set. And we do that artificially by using tools, models to try and sort of basically have more examples to train the machine with. That is not covered by the protection anymore because it's part of the creative process, not just the collection. So you see here again, yes, sui generis protection can be invoked, but not always. And you have to be very aware of the perimeter where the regulation and the protection applies. So data augmentation, training, the process itself also is not falling under the remits of the protection. And in fact, that's basically the idea here. You could protect the training set under certain conditions when there is no creation involved, but the creation of the model that you probably could consider as a sort of a database because it's a collection of parameters. Why not? But it's because it's being created by the pipeline of the machine learning pipeline, it doesn't fall into the protection. So, right, training corpus and data would not be protected if generated. What about patents? Patents, of course, could be an option for many reasons. And actually, we see a massive trend in the uptrend in filings of patent families here across the world. That's a WIPO report from 2 years ago, showing the growth in scientific publication, but as well the growth in patent filings at the various offices in the world. Machine learning actually has been a driving force in that momentum. You see, if you're comparing to other categories of I would say artificial intelligence in the broad sense, it's dominating by orders of magnitude. And it shows again that the impact those new technologies, this paradigm shift I was mentioning before, is having in the patent world. So what do we mean by protection with patents? Well, actually, the offices, and actually pretty much in almost an harmonized fashion, have come up with a set of solutions, a set of rules to cover the patentability of AI as such. We talk about, for example, the pipeline, the process, the model, the hardware also related to the AI. And to do so, we follow sort of a two-step approach. There's two hurdles. The first requirement that requires to have an invention. In law, of course, we need to have an invention. And because patents should not be assigned to abstract objects, abstract concepts. They're excluded from protection. And algorithms are very much abstract. In essence, they're very mathematical. So as such, they are not protected. But when they're combined with technical entities, a computer, for example, a machine, a sensor, then the conjunction and the association in synergistic fashion is actually potentially protectable by a patent. But that's the first stage only. And once you've sort of passed that first hurdle, you go to a second requirement that needs to look at the novelty, inventive step, and industrial application of that particular claimed invention. And to do so, the offices and the case law have come up with a solution to try and basically deal with those very complex objects, those mixed type invention, mixed in the sense that there's a conjunction of technical objects, the computer, for example, and non-technical as such component, the algorithm. So the way here is actually how to handle it has been defined in a very important decision called COMVIC, it's T64100, and it tells us that decision that all the features contributing to the technical character of the invention need to be taken into account for assessing the inventive step. It means essentially that you can't really say, okay, there's an algorithm there, I'm getting rid of it, it's abstract and I'm looking at the rest. You need to look at the algorithm in context. And the quick question is to ask ourselves is whether the mathematical construction, the algorithm, contributes to the technical character of the invention. If it does, you've got an invention, right? And it does so in a very specific set of situation. It does it if it's particularly adapted, specifically adapted to a technical implementation, and or if it's applied to a field of technology. So if it fills in a sense that definition, that set of options, it's a patent. You see, there's AI is no exception. AI can be patented provided those rules are met. That's it. It's quite simple indeed. I mean, it took, of course, a lot of work to sieve through the set of case law and to get a sense of that simplicity at the end, to boil down to those simple rules. But in practice, that's where we stand. And in practice, defining the technical character is made on a case-by-case basis, also looking at the extensive body of decisions from the boards of appeal, for example, the European Patent Office.
Jean-Marc, sorry, if we may come back, there's a very interesting question from Warsaw, Poland, on the sui generis question. Since algorithm is so important for artificial intelligence, do you believe that it should be legally protected by some sui generis rights, especially given that algorithms may not be copyright protected? It may be protected through a trade secret, but it may be hard to keep it confidential. That's the question from the audience.
It's a very good question indeed, and it's a very important one because we need to go back to the function of the IP rights. Yeah. And you see there's always a trade-off. There's always a balance there. Sometimes that balance is decided by judges, by officers at the EUIPO, at the intellectual property offices all over the world, by deciding where to stand. And it's a bit of a case of an exchange of good procedure. For example, in the case of patents, you give away a monopoly for a limited amount of time for a limited geographical area in exchange of divulgation, of teaching the public at large about the nature of the invention. So there's a trade-off. What you don't want to do is actually give away too much. If you were to give a protection, even a sui generis protection for algorithm, we would have to define that notion of algorithm. If you look back to the Al-Khwarizmi definition from the 9th century, so it was where the name came from algorithm, it's just, I mean, it was a mathematician by all means, but the word that was translated in Latinized to algorithm later on basically means a step of procedures to solve a problem in a repeatable fashion. So if you have that, and other people have added some caveats, some more technical aspects to that, but basically it covers a recipe, like a cooking recipe, or a way to solve the Rubik's Cube game, for example. All that are algorithms. So we would have to find, again, a definition, a proper definition that stands the scrutiny of time. It would be very hard indeed, because we touch on something very abstract. So I would say, even though it's very useful, the current trade-off is not so bad. We're focusing on the technical character in the context of technical applications, and it seems to be okay, because when the object, the otherwise abstract object, is being applied to something industrial that serves the common good, finding a new molecule, controlling a server, a computer, or a wind turbine, or a pacemaker, we would say, okay, indeed, that, in the sense that's a narrow application of that algorithm. It's not an abstraction anymore. It's really in the field. It's working in the field. In that case, it maybe deserves protection. Protecting the object as such, the algorithm, in a sense, may be too much, because if you do so, you would maybe grant an exclusive right to prevent others from doing anything using that particular object, and that may be too much. It's like preventing people from using Pythagorean theorem. It's very useful. We use it all the time, but maybe for good reason we want to leave it open to the common good and not allocate it to a particular person or legal person, for example.
Thank you for that.
So, yeah, but it's a very good question. And it's also a very important one, because people think always about sui generis rights, in particular of AI. But again, I think we have to be very wary of extending the remits of the IP rights too far. And we have to be looking at what the function of the IP rights and what's existing at the moment, because it's these sets of IP rights are the locus of a huge amount of investments. I mean, a collective intelligence, I would say, where people are really finding the right balance, the right compromise between these various aspects: the common good, transparency, sharing on one hand, and monopoly exclusive rights on the other hand. So finding that balance is done collectively, and we all engage in that process. Even today we are. So that makes it quite interesting, but also challenging. So, the tabula rasa and creation of new rights may be an easy way out at times. It's fashionable, it's fun, but we have to be very, very careful of the consequences.
Mm-hmm.
So the current landscape is actually very broadly, I would say, I don't pretend to have covered all the aspects, of course, but you see it's a collection of options that we have today. And it's working, but it tells you in a sense that you have to see AI as that composite object. It's very, very, I would say, error-prone to just isolate one branch and to see it only as a model, for example, or only as an application. We have to really look at it. And if you open this AI green box, it's not a black box here, you see that there's a sort of a deployment of that pipeline that also invoke many, many different actors and maybe different ways of protecting the subcomponents. So it's a complex entity. Let me talk now about the protection of the products of AI. Now, before I talked essentially about AI as such, the data, the process, the hardware, the applications, the AI object. But AI, as I mentioned before, can produce new objects. Is the product, for example, patentable? Well, the answer is clear. I mean, if it's an invention, if it's not obvious, if it's novel, if it's industrially applicable, there's no reason why not. You look at the invention in law, and if you follow the set of the procedure, if you follow the rules, basically there's no reason why to forbid product creating using AI from protection, just in the same way as using a computer or a calculator or just a set of experimental tools does not prevent from that particular object to be protected, the output of that particular experiment to be protected. So traditionally, we would come up with that solution. Human beings would try and experiment and have a sort of a spark of genius sometimes to come up with that particular object. It's a real object, it's a mechanical connector. And we would ask ourselves, is it patentable if it's, if it serves a particular industrial application? And to do so, we would basically ask examiners at patent offices to look at the prior art, compare it, and check whether or not the solution is obvious.
Jean-Marc, there's a question, sorry, and it's not directly related to this. It's the National Cyber and Information Security Agency in the Czech Republic asking, what do you say on some opinions about the black box, that people cannot predict AI results?
Right. Again, it's a very interesting question that goes far beyond the field of IP. I mentioned before that some machine learning models are close to being interpretable. I mean, we can translate it into a narrative that makes sense to human beings. For example, the decision trees with that hierarchical separation into sub-rules that each are quite simple, and we can follow node by node, branch by branch,
Correct.
the set of rules to arrive at a particular decision is something amenable to interpretation. Fine, that's one. For deep neural networks, where we have billions of rules, hundreds of billions of rules, it's much harder to do so. In that particular case, that's why we talk about black box.
Of course.
We control the box, in a sense, we control the parameters, but it's very difficult to translate the reason why a particular decision was made in terms that make sense to us. Why? Because there's so many rules. The decision is distributed inside that meander, that maze of rules. Very hard indeed. It's important in some issues where, for legal reasons, we need to have access to the logic involved in the decision-making process. I'm quoting the GDPR here. So if the decision is made that has a legal impact on a subject, a person, for example, then it might be important to look deeper in the construction of that decision. Why? Because if the system makes an error, we want to correct it.
Correct.
And also we may want to identify the fault and the persons responsible. So for that reason, we need to go into something that looks like a transparency enforcement of that black box model. We need to peek inside the model and try to identify what's happening. So it's a very technical requirement, and not an easy one again. And it's a very active field of research at the moment. So I would say that's a clear question of interest for the scientific community and also for the legal community.
Thank you. Thank you, Jean.
So coming back to the patentability of AI-generated artifacts, what would happen in that situation where a user clicks on virtually clicks on a neural network and obtain the same shape at the end? Would that matter? Well, for the patent offices, not so much actually. We would check essentially the same condition. We would ask ourselves whether that particular shape, that particular connector is novel, inventive, and industrially applicable. If it is so, it's an invention. You see what happened, before its creation, in the mind of the users, whether it was easy or hard, doesn't really matter. Whether you used a computer or multiple computers, a very simple decision tree or a very complex deep neural network is not a question that is being sort of in the mind of the examiner, who analyzes in an objective fashion or tentatively objective fashion the invention that's being claimed. You look at the claimed subject matter, not the process necessarily that produced that object, that particular claimed subject matter. The question we ask as examiners is whether that particular comparison between the prior art and the invention is obvious to the skilled person. The skilled person is a fiction, a legal fiction, but still a human being. Okay, this human being can use tools, for example, a computer, that's fine, but we need to be able to prove that connection, that causal link between the prior art and the invention. And the crux of the matter is related to that would that I've underlined here on the slide. And the question we need to ask as examiners in patent offices is, would the person having ordinary skills in the arts, the posita, arrive at the invention? The question is not if that person could arrive, potentially, using a very, very complex model that can do many, many fancy things, it could arrive at that particular solution. No. We have to demonstrate that indeed that intermediary, the person skilled in the art, would necessarily, I would say, or with a certain degree of certainty, arrive at that particular connector. You see, with a very convoluted shape here. Could you say so? Probably not in that particular example. And if it's not obvious, if no obvious link is identified, no causal obvious link is identified, then it's inventive, then it can be an invention. So you see issues of inventorship that have been claimed recently, for example, in the Dabus case, I'm pointing out now, where certain inventions were filed at various offices in the UK, Europe, in the US, claiming that the device had invented on its own certain invention. It was filed by the human, but it was listing, trying to list a machine as an inventor, as really the real inventor, is sometimes overstated and denied for good reasons. The particular invention was related to a food container of a particular fractal shape that could be connected using the specificities of that geometry of that shape. And basically the contention was about the nature of the inventorship. Could a machine be an inventor? Well, the decision actually was quite easy by the offices that didn't really look into the detail of the supposedly very, very smart and intelligent system lurking in the background of that inventive process. And to be honest, there's not much detail about that particular object, but it's an interesting case by any means. And the decision, again, was very simple because the rules of the European Patent Convention, but it's the same in the UK and in the US as well, tell us that we need a human as an inventor. Human need to be in the loop. And actually, there are plenty of humans in the loop. We'll see that in a second.
Jean-Marc,
So
there's a question related to this. Could there be, from Switzerland and France, could there be a broader problem in the future with a denial of registration for patentable inventions that have, due to being created by AI, no human inventor, as in this decision? How AI may affect the patent system in the future?
Well, again, that would deserve another webinar. That's a really, really important question. Yeah, it's an important issue because, of course, there's a societal transformation at stake here. When we're using more and more tools of an abstract nature, of a very complex nature, that automates certain cognitive properties. It does not mean that the system is directly created, automatically rated, autonomously created by the machine. I mean, of course, we will need to go through examples to give you to put some meat on that statement I'm making. But in many situations, and actually in all situations, human beings are defining what matters, in a sense, in terms of, for example, what we call the objective function. Why am I using that particular machine? the particular deep neural network. To which end? The machine does not come up with the idea of food container. The machine has no idea what food means. Human beings know what foods mean. We taste it, we appreciate it, it matters. A machine, just like it's a series of 0 and 1, doesn't mean anything for the machines. For the food container before, because if it was just a container, again, the notion of container does not pertain to the neuron framework of that particular machine learning application. So it's something where human beings took steps in framing the question. So we're not there at the stage where we could say machines autonomously arrive at a creative invention, a creative artifact. It's something that's closer to science fiction or closer to artificial general intelligence. It does not mean, just to come back to the question, that there won't be impact on the way the patent system need to tackle certain type of inventions. But it does not really to do with that particular issue. Maybe it's the rhythm, the sort of the program of obsolescence, the pace at which invention evolved, in particular in the field of immaterial processes like algorithmic, mixed type inventions, computer implemented invention, where indeed it goes so fast indeed that the current system of IP rights wasn't devised to tackle maybe that pace of change.
Exactly.
Certain issues also of, again, definitional boundary between abstraction and non-abstraction may be tackled. What is a technical application? It's something patent offices and offices of the world are very much invested in and trying to find the boundaries so that we can maybe serve the public in the best capacity, and including the companies, of course, that find those patents.
Thank you.
But it's a broad topic. So just to conclude in a few words, beyond the issue of that Dabus case, where indeed the decision were highlighting the necessity of having an inventor in the loop and naming that particular inventor in the title. In that particular case, the applications were rejected for formal reasons. We need to look at the presence of those human beings in that pipeline. And as I mentioned before, this may be the take-home message, humans are everywhere. Humans are in the loop. They're not necessarily always in strict control of the outcome for the reason we mentioned before about the complexity of that object, but they participate in that control in terms of validating, for example, the outcome, in selecting the good ones from the bad ones. And that can be automated partially, but only partially. So humans are everywhere in that construction. It's very important to keep that in mind. And if I take a step back even further, looking at the collection of the data where the sources, the signals could be personal or non-personal, are collected and stored and labeled, as I mentioned before, are assigned to those for example, images or data by micro workers through something called, for example, the Mechanical Turk from Amazon, platforms where people work and being paid to that work. So you lots of human beings to create this set of entities to train in a supervised fashion a machine learning system. Again, as I showed in the previous slide, many algorithmic choices in terms of model optimization, hyperparameters, cost function, test and validation, selection, and so forth, and even at a user level, many choices again. So you see human beings are everywhere in that pipeline, and it's a good thing to keep in mind. Very quickly, because I know you've had a webinar on that topic, but the product of AI could also be works of art. Here again, there's specific conditions, just briefly mention them. You can look at the slides later if you want, but again, it's an important field. And here again, humans are everywhere in the loop. So it's a bit easy to talk about strictly automated pieces of art. You have to peek inside again the machine and be careful to open that box and in a technical way also, look inside the black box. We can click to create for sure. Of course, we are building those machines and leading, commoditization is something that happens in the field of AI. So we can build models that other people can use and click and produce output. But in that case, are they really meeting the condition of originality for works of art? That's something that's being questioned. Giving you a couple of examples where companies are doing that. For example, JukeDeck, a company that's been recently bought by TikTok for an undisclosed amount, we're claiming, basically reducing by a large amount the fees involved in the creative action of generating a jingle, a piece of music, for example, by just clicking to create that piece of music. And you can see it in the graphical arts as well, where you can have filters also that create works of art in the style of Van Gogh, for example, or even in the field of logo creation that could matter to the EUIPO,
Yes.
because you can produce those new shapes and even, maybe fake existing ones by using AI generators, and why not also using AI enforcers to check the proximity of those, counterfeiting shapes with the existing one, the protecting ones. So that's something that shows you that there is an end-to-end strategy in AI protection, and we need to have an integrated view of that AI pipeline. I sort of emphasized that throughout the talk. We need to look at beyond IP, for example, in the context of GDPR, personal data. That's something very important to put AI and IP in context, to balance the rights as well. And we need to have a sort of a broad understanding of the function of the IP right to be able to do so, including impact and usage on fundamental rights, privacy rights, maintaining of privacy of individual and companies alike, but also issues, as we talked about, of interpretability and explainability, which model work for particular application, for particular sector. So sector-dependent contextual vision is important, also mentioning again the fundamental rights. And that's the last point is related to transparency, maybe building models that are amenable to being explored, analyzed, just to avoid reproducing the same mistakes over and over again if there is a fault. So I'll conclude with this view and thank everybody for the attention.
Thank you very much, Jean-Marc, for demystifying AI and IP. And as we can see, AI can be applied to all fields, and you need an end-to-end strategy for AI protection. We'll be addressing AI in more webinars, so stay tuned. Thank you very much for your attention, and see you next week, 10 o'clock Tuesday. Bye-bye.